Make a little nip hustle. Big shout out to SPI, Spot Alert. You know, I'm in the black box. Had to come through, tap in, show love one time. Yeah, y'all make sure y'all subscribe. Stay tuned. All that.
Back in the black box, getting it cracking. Big 30, one of them names I ain't heard about, don't know nothing about, till it become popular for something terrible, tragic, negative. At least nobody didn't lose their life. But, you know, I quit 504 Street Stories, and he said it's all bad for Big 30. The constant, consistent, continuous content creation campaign continues. And we finna see what he say Big 30 you been up to with no further ado. Oh, my mama, I just imagine it would be some interesting content to go through. You dig it, Lars? Give me a moment. Okay, bam. Bam. Oh, there we go. We can do it right here. Bam, I see it. Oh, no, bam. I'm moving too fast. Oh, okay, here we go. 5, 4, 3, 2. Big 30, is it right there? Yeah, bam. 1, let's go. Let me back it up to the beginning. Bam, let's go.
Rapper with the stage name Big 30 was granted a $100,000 bond today. He was in federal court as he faced charges for an alleged robbery and kidnapping of the rapper known as Gucci Mane.
Rodney Lamont Wright Jr. came up in Memphis, Tennessee, born in 1999. The federal government knows him as a co-defendant in a kidnapping conspiracy case in the Northern District of Texas. A judge granted him bond. The government immediately moved to block it. The man on the outside is giving interviews that are actively damaging the legal position of every defendant in this case. 3 separate problems converging on one man at the same time. This is where things currently stand. In 2018, 30 pleaded guilty to gun charges in Memphis. The fact did not stay buried. The prosecution raised it at his bond hearing in the current case as a direct challenge to the defense's claim that their client has no felonies on his record. His attorney, Arthur Horn, stood in the federal court and told the judge 30's record was clean. The prosecution produced a 2018 affidavit and disputed that statement directly. 2 contradictory accounts of the same man's legal history now exist inside the record of an active federal kidnapping conspiracy case. That is not a minor procedural disagreement. There's a credibility fight happening in real time between defense and the government has subpoena power. 2 years after the 2018 plea, in October of 2020, 30 was stopped on Interstate 22 in Brookside, Alabama at 4 a.m. He was a passenger in a Ford Expedition rental car traveling from Atlanta to Memphis. Brookside narcotics officers conducted the stop and recovered a loaded Glock 40 handgun, over $17,000 in cash, methazine, codeine, and marijuana individually packed for sale. 30 was charged with felony possession of marijuana and drug paraphernalia and unlawful possession of a firearm. Brookside police identified 30 as an alleged gang member with pending charges from Tennessee and held him for out-of-state extradition.
Back of a squad car Thursday morning to a mugshot. Brookside, Alabama police provided these pictures of rapper Rodney Big 30 White. Police tell us White was on his way to Memphis from Atlanta when narcotics interdiction officers stopped him and another man. Brookside is about 3.5 hours outside of Memphis. White was the passenger in the rented Ford Expedition they stopped. While officers have not said why they pulled the SUV over, they are telling us what they say they found inside. $17,000 in cash, a loaded Glock 40 handgun.
She said that like that's illegal. Like that, she said that worse than she said the gun.
Promethazine and codeine, and marijuana they say was packaged to sell. Police say White is a gang member in Memphis. He has pending state and federal charges in Tennessee and is waiting federal extradition.
How those charges were resolved is not in the public record. No plea documents, no dismissal records, no publicly available court disposition. His attorney's statement that 30 has no felonies is the only public account of how that situation concluded. The prosecution's willingness to introduce the 2018 affidavit at the bond hearing signals that they are not going to let any prior legal history sit quietly in the background while they build this case. Prior criminal acts are admissible in federal proceedings under specific rules of evidence. The government knows 30's file. They're definitely going to use it. The affidavit documents three specific acts attributed to 30 on January the 10th. He retrieved the bag that contained the firearm when Shiesty allegedly gave the order. He filmed the forced contract signing on his cell phone while a weapon was pointed at the victim. And he walked to the studio door, closed it, and held it shut with his body weight while the robbery was in progress, preventing Gucci's security team from entering. 3 acts. Each one places him inside the offense at a critical position. Under federal conspiracy law, a defendant does not need to have held the weapon to be held fully responsible for the outcome. Active participation in furtherance of the conspiracy is enough. Government has pre-documented acts to work with. 30 appeared in federal court in Memphis on April the 7th of 2026. The defense brought 2 witnesses to the stand. His father, Rodney Wright Sr., confirmed he lived with his son. Kay Brown, general manager at NLS Entertainment, testified that 30 was signed to the label and in the process of signing a 7-figure distribution deal on top of his already existing contract. Both witnesses spoke to his community involvement and his financial support of his 4 children. The defense constructed the argument that the court expected to see: roots, responsibilities, accountability, reasons to appear for future proceedings. The judge ruled in 30's favor: $100,000 secured bond, requiring a $10,000 payment for release, home detention with electronic location monitoring, travel restricted entirely to West Tennessee, with the sole expectation of required court appearances in Dallas, no contact with any co-defendants, mandatory drug testing supervised by pretrial services. He was permitted to continue working. The prosecution stated its intentions to appeal before the courtroom cleared. The bond the judge granted was not a signal that the government's case is weak, homie. Pretrial release decisions and trial outcomes operate on entirely different legal standards. A defendant can be released pretrial and still be convicted. The bond hearing is about risk assessment, flight risk, danger to the community, not about guilt or innocence, bruh. The judge assessed that risk, landed where she landed. The prosecution assessed that same risk and immediately disagreed in writing. Under the Bail Reform Act, federal judges weigh 4 factors when determining whether a defendant is released pre-trial: the nature and seriousness of the offense. A federal kidnapping conspiracy with a maximum sentence of life in prison puts this case at the highest end of that scale. The weight of the evidence against the defendant. The government's case includes eyewitness identification, surveillance footage, cell phone records placing 30 at the offense location, and his documented acts inside that studio. The defendant's history and characteristics, community ties, employment status, family obligation, and prior legal history all enter that calculation, and the danger the defendant poses to the community, and the risk he will not appear for future proceedings. Judge applied those 4 factors and determined the defense presentation was sufficient enough to warrant release under conditions. What the government is arguing in that appeal is that the judge underweighted the severity of the offense, the strength of the evidence, and gave too much weight to the community ties and family circumstances presented by the defense. To keep it real, that is a legitimate appellate agreement in the federal case. Detention appeals in federal court are not rare. In cases involving violent crimes with documented evidence, government wins those appeals at a significant rate. Hours after that bond was granted, the government filed a motion and request to stay pre-trial release order. The stay motion is not an appeal on the merit. It is an emergency request asking the court to pause the release order while the appeal is being prepared and filed. Without that stay in place, 30 walks out. With the stay, he remains detained until the appellate process plays out. The government's filing made clear they were not willing to let him walk while they prepared their challenge. Government stated grounds were the seriousness of the offense conduct, the criminal history and the potential danger he poses to the community. Magistrate Judge Ann Christoph issued a temporary stay, giving the government until April the 13th of 2026 to file its full brief in support of revocation. That's not a long time window, homie. Federal prosecutors in the Northern District of Texas do not file motions like this casually. They file it because they believe they can win it. And the April the 13th deadline means by the time this video uploads, 30 status, home detention, or federal detention may already be determined. His attorney, Arthur Horn, publicly stated he expected the prosecution to appeal and indicated the outcome would hinge significantly on whether Gucci Mane cooperates with the government as a witness.
Initially, I guess she found that there was probable cause for the case to move forward. And then today in the detention hearing, she did grant him a bond of a secure bond of $100,000. U.S. Attorney's Office in the Northern District of Dallas is going to file an appeal, and they're going to appeal the judge's decision, and we will have to have another detention hearing in Texas. He has no interest in whether Pooh Shiesty has a contract with 1017 or he doesn't. They're going to make music together regardless. I think the interesting thing that we've seen in the last couple of days is that Gucci Mane has come out publicly and said that he's not cooperating with the government.
That is a notable statement.
That is a big statement. That'll be a big win for Pooh Shiesty and his peoples. But what about the fact that this police was supposed to be involved as far as being a victim? That's going to throw a wrinkle in all that.
It signals that the defense views the government's ability to prove their case as dependent on victim cooperation, and that any public indication of non-cooperation by the primary victim is something that the defense intends to use. But the defense cannot control this, what happens outside of that courtroom. While 30 and the other defendants are navigating detention hearings, bond conditions, and government motions to revoke their release, Hernandez Govan is giving interviews voluntarily, publicly. He is claiming to have seen footage of the robbery. He is claiming to have been in direct communication with at least one of the men charged in the case. And he is putting all of that into the public record. While an active federal kidnapping conspiracy case with 9 defendants and a grand jury seated is moving forward in the Northern District of Texas. Here is the legal exposure Govan is creating for himself. He has seen video footage of the offense and is publicly describing what it is on that footage.
We live in a crazy time. I'm not putting this on him because I don't believe he got no jacket as far as how you can rap and become famous. But if I understand correctly, he was an alleged hitman, murderer for hire. And now he on big platforms, politicking, crispy clean. I think that's Cam Capone on. That's crazy. We live in a crazy time.
Identified himself to federal investigators as a person with direct knowledge of evidence. That is not a gray area, homie. That is someone telling the world, and by the extension of the government, that they have information relevant to the active federal prosecution. Federal investigators can subpoena him before the grand jury. They can compel his testimony under oath. And if what he says under oath contradicts anything he has already said publicly in those interviews, that contradiction becomes perjury he created entirely himself. The communication piece is where it gets worse. Govan is publicly claiming he has been in direct contact with one of the defendants. Phone records in this case are already part of the government's evidence. Subpoenas went out to multiple carriers for multiple defendants. If Govan's number appears in those records and a man publicly claiming to have been in contact with a defendant, assume it does, then the public statements about that communication have made them easier to find, easier to question, and easier to connect to the case than he would have been had he simply said nothing. Every time Govan describes what he allegedly saw on that video, is putting details of the offense into the public domain. Those details can be used by other witnesses to corroborate or build on what they already know. They can be used by prosecutors to establish the public narrative of what occurred before any of those 9 defendants had a chance to challenge the government's account in court. Govan is not a journalist. He is not an attorney. He has no privilege and no protection. He is a man voluntarily providing information to the public that the government would have otherwise had to obtain themselves. From a street perspective, the question answers itself. 9 men, no federal defendants. Their cases are active. Attorneys are telling them not to speak. Any man who presents himself as someone who understands the code of the streets is sitting down for interviews, describing what he claims to have seen and who he claims to have spoken to. The streets have a word for what that is. The federal government has a use for it. That April the 13th deadline has not arrived. The indictment is on its way. 30's bond status is being contested in filings by the government. His prior legal history, a 2018 guilty plea, the prosecution raised in open court. The criminal complaint places that boy inside the offense pre-critical moments, and Hernandez Govan is doing interviews that are handing the government information without a single subpoena required. Federal kidnapping conspiracy, maximum sentence of life in prison. A bond fight the government is not letting go. Prior record, the prosecution is not letting sit. And all of the chitter chatter from someone with no formal role in the case who is making the inside of that courtroom harder to navigate for every person whose name is on that criminal complaint. This case is not getting lighter, homie. It's getting heavier. And for 30, every day that passes without a resolution is another day the government has to build on what it already have.
Oh, wait, I didn't know what we was really finna see, but I guess he's saying, oh boy, ain't no good running around talking too much. But that's the era we live in. Everybody is doing a whole lot of talking. Like he said, this dude is really from the culture of criminality. Supposed to be a gangster. From what I can understand, an alleged hitman. I don't know what he's doing on anybody's platform, running his mouth. Oh, my mama. Yeah, but that's the time we live in. I really can't say I'm surprised. Oh, God.
Smack a little nip hustle. Big shout out to SPR, Spotter Loc. You know, I'm in the black box. Had to come through, tap in, show love one time. Yeah, y'all make sure y'all subscribe. Stay tuned. All that.